to ask the registrar to call out the number and name of this case.
This is IT 95-17/1 I, the prosecutor, against Anto FURUNDŽIJA.
Let me check whether the equipment for interpretation works. I would like to ask the accused if he can hear me in a language he understands. Can you hear me?
Yes.
Thank you. Now, we may now commence with this hearing. As you know, this is the initial appearance of the accused before the International Criminal Tribunal for the former Yugoslavia. This hearing is being held in accordance with the statute of the tribunal and our rules of procedure and evidence to charge formally the accused. As you know, these proceedings are being recorded and will be available to the public. Rule 62 of the Rules of Procedure requires that the accused, after having his indictment confirmed by a judge and after having been arrested and surrendered to the custody of the International Tribunal, must be formally charged at a procedure described as the initial appearance. I would like now to ask the accused to rise and state for the trial chamber his name, date and place of birth, and the name of the attorney whom he has chosen to represent him.
My name is Anto FURUNDŽIJA, born 8th July 1969 in Travnik, in the Travnik municipality. Mr. Bjork.
Thank you.
You're welcome.
Now, may I have the appearances for the prosecution?
Good afternoon, Mr. President, Your Honors, and Counsel. My name is Mark Harmon. I represent the prosecutor's office this afternoon in these proceedings.
Thank you. Now, I will now turn to the counsel for accused, and I would like to ask him to introduce himself. Could you introduce yourself and spell your name out clearly? Please, would you also indicate which bar you work with?
Poštovani predsjedniče.
Your Honor and Your Honors, my name is Srđan Joka. I am an attorney from Croatia and am a member of the Bar Association of the Republic of Croatia. I was told to spell my name.
N-J-O-A-K-A. I think that's all.
Thank you. Thank you so much. Now, could you confirm that your qualifications, credentials, and other necessary documents have been provided to the registry of our tribunal?
Da, ja to mogu
Yes, I can confirm that, and I can add that I am on the roster of the appointed defense counsel at the registry.
Thank you. Now, let me say a few words about the rules which govern our proceedings today, and I will try simply to summarize them very quickly. As you know, Article 20 of the Statute of the International Criminal Tribunal requires us, inter alia, first of all, to satisfy ourselves that the rights of the accused are respected, then to confirm that the accused understands the indictment, and thirdly, call upon the accused to enter a plea to the charges against him in the indictment. You may also know that the rights of the accused are detailed in Article 21 of the Tribunal's statute. Now, this article provides, inter alia, that the accused shall be entitled to a fair and public hearing. He shall be informed promptly and in detail, in a language which he understands, of the nature and cause of the charges against him, and that he must be given adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. Now, as I have already indicated, Rule 62 of our Rules of Procedure and Evidence of this tribunal governs the initial appearance. Now, this trial chamber must be satisfied that the accused's right to counsel has been respected. The indictment must be read to the accused in a language he speaks or understands, and the trial chamber must be satisfied that the accused understands the indictment. We are then required to call upon the accused to enter a plea of guilty or not guilty on each count. If the accused fails to enter a plea, we are required to enter a plea of not guilty on his behalf. In the case of a not guilty plea, we will instruct the registrar to set a date for trial. In the case of a guilty plea, we will instruct the registrar to set a date for the pre-sentencing hearing or on any other appropriate dates. Now, I would like to ask defense counsel whether he and his client have received copies of the indictment in a language which they understand and whether the contents therein were understood. Have you had adequate time to confer with your client in preparation for this initial appearance? This is a question addressed to you.
Časni sud.
Your Honors, both my client and I have received the indictment and had adequate time to prepare for this initial appearance before the trial chamber.
Thank you so much. Now, the indictment, as you know, was issued by the prosecutor on the 2nd of November 1995, and it was confirmed by Judge Gabrielle Kirk McDonald on the 10th of November 1995. Judge McDonald also ordered that the indictment should not be divulged. This order still applies, and the reading of the indictment today will be in compliance herewith. So, in principle, under our statute and our rules, as I say, the indictment should be read out here in court. I wonder, however, whether the accused is prepared to waive his right to the public reading of the indictment. I wonder whether he has been in touch with the defense counsel on this issue.
Yes, Your Honors, we have discussed this subject, and my client has a very clear idea what it concerns, and on our part, we agreed that there is no need to read it here in the courtroom.
Thank you. I will now turn to the accused. May I ask you, please, to rise, Mr. FURUNDŽIJA. Thank you. Your counsel has informed the trial chamber that you have received a copy of the indictment in a language which you understand and that you comprehend the contents of the indictment. The indictment has just been read, well, you waived your right to the public reading in reading out of the indictment. I would like to ask you whether you may confirm whether this is correct, the indictment is correct, whatever I've been saying is correct, and whether you have any questions concerning the indictment. This is my main question, whether you have any questions concerning the indictment.
Your Honors, I have no questions, and it is correct what my counsel has said.
Thank you. Now, I am now going to recall each of the 3 counts against you. Please tell the court whether you plead guilty or not guilty after I have put the counts to you, each of the 3 counts to you. The form of words we wish you to use is either I plead guilty or I plead not guilty. Have you understood that?
Yes, Your Honor.
Thank you. Now, I will ask you about count 12. A grave breach, torture, or inhuman treatment recognized by Article 2b of the Tribunal Statute. How do you plead?
I plead not guilty.
Count 13. A violation of the laws or customs of war, torture, recognized by Article 3 of the Tribunal Statute. How do you plead?
I plead not guilty.
Thank you. Count 14. A violation of the laws or customs of war, outrages upon personal dignity, including rape, recognized by Article 3 of the Tribunal Statute. How do you plead?
I plead not guilty.
Thank you. You may now be seated. Mr. FURUNДŽIJA, you will be remanded now to the further custody of the International Tribunal and kept in the detention unit until further order is made. Would the registrar please note the pleas of the accused? Now, as the accused has pleaded not guilty to the charges against him, it is necessary to consider the organization of the work of the trial chamber and the setting of a date for the trial. May I ask the registrar whether the registry is able to set a date for the trial right away?
I cannot answer this question at this moment, but the registry will do everything it can to set the date for the trial as quickly as possible.
We shall therefore have to await confirmation from the registry. Now, let me now move on to a few problems which I would like to, questions which I would like to raise. First of all, let me remind briefly the obligations of the prosecutor. Under our rules of procedure and evidence, the prosecutor has an obligation, and this is spelled out in Rule 66, to make available to the defense within 30 days of this initial appearance copies of the supporting material which accompanied the indictment when confirmation was sought, and all prior statements obtained by the office of the prosecutor from the accused. This is a clear obligation set out in our rules. Furthermore, the prosecutor is obliged to make available no later than 60 days before the date set for trial copies of the statements of all witnesses whom the prosecutor intends to call to testify to trial. At trial. The statements of any additional witnesses shall be made available as soon as decisions to call those witnesses are made. Further orders may be made by the trial chamber in the interests of a fair and expeditious trial for the accused. Now, I would like to ask if any such documents have already been provided to the defense. If not, may I ask the prosecutor if he could indicate a time frame within which these materials can be provided to defense counsel.
Mr. President, no such materials have been provided to the defense to date. We will comply with the rules set forth in Rule 66. We will provide all supporting materials to the defense within 30 days of the initial appearance. My best estimate at this point, Mr. President, is that we will provide the supporting materials to counsel on or before the 5th of January, which is well within the time frame set up in Rule 66. I am not in a position to comment on the second part of the rule, that is, when we have to provide the statements of all witnesses, but we will comply with the rule, that is, we will comply with the statement, providing the statements within 60 days. No later than 60 days before the date set for trial. So,
yes. Thank you. Thank you. Now, Mr. Joka, do you understand what the prosecutor has just pledged? So you will be entitled, within the time frame he has just set out, to have all the documents that were attached to the indictment and the request for confirmation which were submitted to the International Tribunal.
Your Honors, I have completely understood that. I only wanted to ask my learned colleague that if possible, and observing the time frame from the Rule 66, if he could provide these documents as soon as possible. But I think that we will meet that deadline. Anyway, thank you.
All right. I see that you are nodding, so you agree. Now, let me also address the issue of preliminary motions. Now, you know that Rule 72 of the Rules of Procedure and Evidence provide for preliminary motions. The parties under this particular rule of our Rules of Procedure and Evidence have 60 days from the date of disclosure by the prosecutor to the defense of all material and statements provided under Rule 66A, within which they must file preliminary motions, if any. Now, other motions may be filed under Rule 73. I wonder whether the parties might indicate their general readiness to proceed to trial. First of all, let me turn to the defense counsel. Generally speaking, are you ready to proceed to trial as soon as these questions are sorted out?
Of course, it is in our interest to have as early a date for trial as possible.
Thank you.
Mr. President, after the hearing and decisions rendered on the preliminary motions, we will be ready to proceed to trial.
Good. Thank you so much. Now, one final point which is of relevance to us concerning the organization of the proceedings is the question of the status conference, which, as you know, is of great importance. So we should be able to set a date for a status conference in order to look in greater detail at the state of preparedness of the parties for trial, and also in order to settle any outstanding issues. I wonder whether the prosecutors could suggest a suitable date for a status conference. Are you in a position to propose a date?
I'm not at this point, Mr. President. I haven't seen the complexity of any preliminary motions. I think it would be, first of all, of interest to us to see the preliminary motions, what they are, before we could set a status conference date. If the court wishes a date set before the filing of the preliminary motions, then, Mr. President, we are at the court's disposal. I would say, I don't have a calendar in front of me. I would suggest perhaps toward the end of January a date for a status conference. By then we will have complied with our initial discovery obligations under Rule 66. Counsel will have had an opportunity to see the supporting materials, and at that point perhaps a status conference would be in order.
Thank you. I wonder whether the defense counsel has any suggestion about concerning a status conference, a date for a status conference.
Your Honors, we will cooperate as much as possible within the time frame that we're operating in.
Thank you. We judges were thinking that two dates might be suitable. One would be the 13th of February in the afternoon, 13th of February, or the other one would be, if this is not acceptable to the parties, would be the 16th of March at 8:30 in the morning. Of course, we would prefer the 13th of February. Sooner the better.
Either date's convenient to the prosecutor, Mr. President. Either date. It doesn't make any difference to us.
What about the defense?
U potpunosti.
We are prepared to comply with the first or the second, the date.
Sorry. Let us go for the 13th of February in the afternoon, probably 2:30 or 3 o'clock in the afternoon. 13th of February for a status conference. All right, it is so decided. Now I would like to ask the parties to notify to the trial chamber, through the registry of course, of any problems that may arise in the meantime, in order that we may dispose of those problems and proceed with a fair and expeditious trial, because we very much believe, and we have strong feelings about that the accused has a fundamental right to a fair and expeditious trial. I wonder whether there are any questions that either party might wish to raise. Yes, please. Any question?
U ovom kontekstu čak
Not within this context, Your Honors. Maybe just for me, for my own clarification's sake, I'm here for the first time. I did not fully understand your initial remarks. Was this indictment now public, the indictment pursuant to Rule 53, or whether this indictment continues to be under seal? Thank you.
No, it is public. There was an order issued yesterday, I think, to the effect that the indictment is public, in part, of course, because some parts are redacted. So the part of the indictment concerning your client is public. Any other questions?
ne, najljepše za.
No, thank you very much.
Thank you. What about the prosecutor?
No additional questions, Mr. President.
Thank you. I wonder whether my colleagues would like to raise any issue. No question? No question. All right. So therefore the hearing may be adjourned. The hearing is adjourned.
All rise for your full of faith.